Good.
Good morning, Charles. I have a question for you. Actually, a couple of questions, but I want to start with the basic question of mediation or litigation in an estate conflict situation. You have siblings, they want to fight about dad's estate, and they don't want to fight, but they do. They are fighting about dad's estate. Would you suggest to them to litigate all the way to the end, or should they try to mediate?
Well, clients will typically say they want their day in court and they don't appreciate how difficult it is to get to court and how long it takes. And it's not a day, it's months, if not years. Um, so in many jurisdictions, mediation is mandatory in these type of disputes, including the jurisdiction where I practice. And therefore, if you're going to end up in mediation, then you might as well consider mediation as an alternative to litigating.
Okay, well, thank you very much. And by the way, I forgot to say off the top, so I'll say it right now. We are here today with Charles B. Ticker, who is an estate litigator and a mediator. So follow-up question, Charles. When is too early? Like, is there such thing as too early? Should people mediate sooner or later? Should they do it right away when they realize there's a conflict, or should they wait till they're on the courtroom steps? What do you say about that?
Well, my feeling is that the earlier is better than later. There are exceptions, but I think waiting to the courtroom steps is probably a little late in the day, because by that point, people have so much invested in the case, both in time and money. Their positions are very entrenched. They maybe been through some bitter motions or examinations for discovery, and they're not in a mood to try and resolve the matter, and seeing they're already at the courtroom step. Having said that, a lot of cases do settle on the eve of trial, but in my view, the earlier you get to mediation, the better.
Okay, so I'm just going to follow up with this just for clarity for our listeners, our viewers today, who maybe have pulled out a piece of paper and a pen, and they kind of want to know the pros and cons of going early. So let's just take a piece of paper, let's divide it down the middle. We got pros on the left, cons on the right. So Charles, what are the pros, just one by one bullet points, what are the pros of entering into mediation early? So should we be going to, what are the pros of going to our lawyer and saying, can you please hire a mediator? I'd like to get my brother and sister in a mediation room. What are the pros of doing that early? And in a minute, I'm going to ask you for the cons.
So one of the big pros is cost. Obviously, the sooner you can resolve your dispute, the sooner you're going to stop paying your lawyer those large legal bills. And so cost is a huge factor. And also, not only are you saving legal costs, but you're saving the potential cost award being made against you if you lose at court. Because at that time the costs will be very high. And also, if you win, you very rarely get all your costs back. So you still could be out of pocket. So saving legal expense is a very important consideration. And another advantage to mediating early is that, as I mentioned before, the longer the dispute goes on, the more the parties get entrenched in their positions, they're more belligerent and less likely to want to budge. Before they get too entrenched in their position, you might have a better opportunity, or you will have a better opportunity of hopefully resolving the dispute.
And before we get to the cons, I guess, wouldn't one more thing be that maybe the earlier you do it, you stop it from getting super ugly? I mean, I'm just thinking Thanksgiving dinner here. Yeah?
Well, hopefully that's very true. If you go all the way to a hearing, or you go to the point where the parties have been through some very bitter litigation, even if they settle in the middle of the court case at trial or on the courtroom steps, at that point, serious damage has been done to the relationship, and they may never be able to reconcile and carry on in any way as a family. Um, Now, with early mediation, there's no guarantee that the siblings are going to reconcile, because typically if they're fighting each other already in a court case, and even at that early mediation, that relationship maybe has been in trouble for many years. However, I have seen cases at mediation where the parties shake hands or even hug and start crying, and it doesn't happen very often, but there is a better chance of it happening if you do the mediation earlier, as opposed to waiting to, you're finished a bitter trial.
That's a good,
Starting a
that's,
bitter trial.
yeah, that's a great point. So that said, promised I was going to ask you if there are any cons to do it early. Any reasons you might not want to do it really early?
Well, I mentioned one of the pros is that you can save legal costs. On the other hand, if you do it too early and you haven't, the parties haven't really incurred the pain of legal costs, they may not yet be aware or feel the pain of the expense, and therefore they're not in a mood yet to settle. So that's one disadvantage, I guess, of going too early. But a major disadvantage can be where you don't have the proper facts or information, or the necessary facts and information that you need to make a decision as to whether or not you should accept an offer or take a certain position. So you need an opportunity perhaps to review medical files if in a will challenge case of the deceased, the medical files or the drafting lawyer's notes. Um, um, if you go to mediation, you're fighting over a house. Well, if no one has done an appraisal of what that house is worth, you don't know what kind of money you're talking about. So you do need some information and documents available to have a meaningful discussion. But having said that, um, people can get a sense of what they feel comfortable with in terms of settlement position without going through a full-blown discovery and production of thousands of documents. I forget who it was. I don't know if it was some judge or um, it was a judge. I think was at a pre-trial, and I think he was talking about the Nortel case that involved, thousands, hundreds of thousands, and billions of dollars of billions of dollars and thousands of documents. And at the end of the day, it was probably just a handful of documents that really had any importance. So, um, and you see this all the time. People will settle late in the day and they say, well, why couldn't we have done this before? I mean, well, they weren't ready, and that's why they didn't do it early on. So I
It's
think
probably
with
your
a bit,
first point, the first point that you made about they haven't felt the pain yet.
right. So I think with a counsel working well together, preparing their clients, and having a mediator who's experienced in these type of disputes, you can get cases settled relatively early, and I'm seeing a trend that lawyers are tending to recommend mediation earlier than later. Um,
And do you agree with that trend? Do you think that's a good idea?
Well, I think so, and because the court cases just seem to go on and on and on. It's just very difficult to get a day in court. Uh, Sometimes there'll be a long trial scheduled, and for some reason, I've seen this happen. The trial, the court says the judge can't be available, and they have to adjourn it, and they lose another several months to get a new date. I mean, this is happening in our system right now. So. And you have the opportunity to put the matters in your own destiny and control the process and make it private. So, do it sooner than later. That's my view.
This has been really helpful. Thank you very much, Charles B. Ticker, for this analysis. I think this will be helpful to a lot of people who are maybe right now trying to decide whether they should go ask their lawyer about mediation. So thank you very much.
Okay, my pleasure.